Welcome back. Even as the row over PJ Kurien refuses to die down, Kamal Nath has come out in defense of Rajya Sabha chairman, deputy chairman, in fact, PJ Kurien, saying that the charges against him are false and that the Supreme Court has also exonerated him.
On the eve of the 1999 general election, a private complaint was filed by the girl in the court on the same issue, which was challenged by Professor Kurien, and the matter went up to the Supreme Court. The Supreme Court found it a fit case for discharge and directed Professor Kurien to file for discharge in the lower court. Accordingly, the discharge petition was filed, which was not allowed in the lower court, but the High Court, in its judgment in April 2007, containing 71 pages, the judgment was 71 pages, discharged him of all charges after considering all points raised by the complainant. It is to be mentioned here that the investigating officer, Shri K.K. Joshua, appointed by the left front government itself, submitted a written statement in the court that Professor Kurien was not involved. So now this is the most important thing. The High Court observed, and I quote, "I find that the circumstances and evidence produced in the matter do establish that the case foisted against the petitioner is false. It is quite unfortunate that the petitioner had to undergo the trauma of facing such a false case of a scandalous nature for the last more than 1 decade. This is what the High Court says. A perusal of the judgment will also show that the High Court decided the private complaint on its own merit, independent of the judgment in the Sweden Ali case, acquitting the accused persons. The left front government went in appeal, but the Supreme Court rejected it in November 2007, thus confirming the discharge. This decision of the Supreme Court has not been challenged so far by anyone. The left front government, which was in power then, did not even file a review petition. An impression is sought to be created that there are some new disclosures. All these disclosures, especially the statement of the convict made after 17 years, which he had an opportunity to make before the investigating team or in the court, do not challenge the established fact of the impossibility of Professor Kurien reaching the alleged place, which is arrived at on the basis of telephone records, key witnesses, including the driver of the state car, the logbook of the state car, and the time and distance involved. This conclusion is reached by 3 investigating teams mentioned earlier. The matter was raised by the opposition in the Kerala Assembly. The legal opinion received by the government of Kerala from the Director General of Prosecution and the senior Supreme Court lawyer who represented the complainant girl. This lawyer who gave the opinion was the one who represented the girl in the Supreme Court, and also of the Law Secretary, Government of Kerala, said that no case has been made.